This question is for the Deputy Solicitor General. I'm wondering, how do you explain the difference in your positions? I know, maybe setting aside the nuances for a second, but how do you explain the shift in your own positions since being outside the administration and then being part of an administration? Is it a difference in facts that you're hearing as an insider? Is it a difference in who advises you? Or is it actually a philosophical change that you yourself have experienced?
It's a great and fair question. I mean, the truth is, as a government lawyer, it's never really about you. I mean, you're just a lawyer for a client, and lots of times there will be occasions when you take positions that you might not necessarily agree with, but that's your job as a government lawyer. I'm not the principal decision maker or anything like that. I'm just, a attorney for the government. But with respect to this, for example, it's very simple. I mean, Bagram, something even when I did represent a Guantanamo detainee, had always said publicly that Bagram was, and the notion of a worldwide writ was ridiculous, that there's something very special about Guantanamo. And I think fairly read that is what the Supreme Court decision in Boumediene is all about, the special, unique status of Guantanamo. So with respect to that issue, which as I take it the kind of heart of your question, it's something that for whatever it's worth, and again, it's irrelevant as a government attorney, but for me personally, it's not something in which I've shifted my position at all. Well, I never really knew much about. I mean, I didn't do anything with respect to Afghanistan beforehand. And as I said, with Guantanamo, from day one, over a year ago, I took myself out of Guantanamo voluntarily. So I haven't seen any new facts. I just read what's in the papers, the Brookings report, whatever.
Mm-hmm. Other questions right here.
For anyone who'd like to comment, what is the purpose of turning someone over to jurisdiction of civilian federal courts if, as the Attorney General, when we was pressed, seemed to guarantee that Khalid Sheikh Mohammed would not be released? Whatever happened, he would not be released. But then what is the purpose of, in effect, saying this person is to be tried in court? Can someone make sense of that situation?
Well, let me try to defend, at least in principle, what the new or not so new administration has done. Look, the reason I like the question is because there's an assumption on behalf of many people that the only relevant imperative that exists in shaping the decision how to deal with somebody is the due process rights of that person, and you either give him the right level of due process, which is okay, or not enough due process, in which case it's bad. We as a democracy, most countries in the world for that matter, properly look at decision to try somebody from a variety of angles. It is about fairness to the person, but it's also about reassuring the citizenry. It's about symbolic affirmation as to what is the significance or heinousness of a conduct involved. So I am not a supporter of his decision, but I can tell you exactly what it means, and I think the administration was pretty straightforward about it. They believe that fundamentally the acts involved are best characterized as criminal conduct. They believe that in that context, the best venue is the traditional criminal justice system, A, and B, that will obtain because military commissions are not favorably perceived overseas, and for that matter, most things military are not favorably perceived overseas, at least by our allies. The guys who like all things military tend not to like us. That you would get a PR coup, and it reflects, again, the way they see this problem. I happen to disagree with both those propositions, but that's a fair explanation. But it's not about whether you be able to get a conviction or what would happen to the person. Yeah, because your point is, even if he is not convicted, he would be subject to being held as an enemy combatant. But does that make sense?
Anyone else want to come up? No. There's another question over here.
Thanks. I'd just like to follow up to that question. The Attorney General assures us that, as was stated, if someone is acquitted who's brought to the United States, that we will continue to detain them. My question is the law really that clear-cut? So, for example, if 50 or so Guantanamo detainees are brought to Illinois and they win their habeas case and are ordered released and there's no place to detain them, or someone is acquitted and there isn't, and there's no place to deport them, is the law really that clear-cut that we can continue to hold them?
Let me, if the other panelists don't mind, I don't think the law is actually clear-cut at all. I mean, I think we have two anecdotal precedents that we can look to. So this is exactly, in both the Jose Padilla and the Ali Almari cases, right? You had someone who was transferred in Almari's case twice between the military and civilian criminal justice system. I think I mentioned this very quickly in my opening remarks. I think there's an important difference about whether you can detain them in the abstract versus whether you can shuffle them back and forth between one form of detention and the other. And I don't think I'm alone. One of the forgotten opinions of the courts in these last few years is the odd concurrence that Justice Kennedy, joined by Chief Justice Roberts and Justice Stevens, an odd golf trio, if ever there was one, filed in Padilla when they denied cert the second time, where Justice Kennedy basically said, I'm fine denying cert, I'm fine sending Jose Padilla to Miami to be tried in a criminal court, but if the government should manipulate the process, right, if the government should purport to re-detain him at some later date in the future, Padilla will be entitled to swift judicial review. And Kennedy then actually cites the Supreme Court's original jurisdiction rule. So basically, as a sort of warning, don't bounce him back and forth to defeat judicial review. So I don't know what the answer is, but I think the precedent is unclear, and I think it's certainly something that's already occurred to at least some of the justices on the court.
Can I just ask my good friend Steve a simple question? What's the constitutional principle which says the government cannot do that? If in both instances the government is acting properly, how is that less onerous or more unfair than the government having put somebody for trial on, let's say, a primary charge and proceeds after that person on tax evasion or numerous other things? The government can do many, which is why those of us who are libertarians are concerned about giving the government too much power. But the government messes up with people all the time in multiple ways. As long as there's no fundamental constitutional problem, what am I missing here?
Well, so I think there are two different constitutional problems. I mean, I think it's true the government messes up all the time. That's not new nor related to the political stripe of the administration. I think the government indeed could, in good faith, have someone in the civilian criminal justice system and then transfer them if they're subject to military detention. There are two problems that arise. If you want to try them, eventually you could run into a very serious problem under the Speedy Trial Act and the Speedy Trial Clause. If you've had them in custody all this time and you've just been moving them around as a way of sort of stalling or otherwise pursuing other remedies. This is actually an issue that has been argued to the 11th Circuit in Jose Padilla's appeal, and I think the decision's pending. But from the detention side, I think at some point a judge is just going to say this is a due process problem. That this case is not moot. You can't keep moving them back and forth. If you have the power to detain them, detain them. If you have the power to try them. But you can't avoid the courts by moving them back and forth just when it's time to be reviewed. So it would be a novel constitutional argument, but I think it's not that hard to see how the government could use an unlimited power to cross-rough for ends that are difficult to justify.
I hate to waste time on that, but it assumes a very peculiar way of moving it. Yes, if you put someone in the criminal justice system on the eve of his trial, you spirit him out of a court's jurisdiction and put him somewhere else in the military justice system, perhaps you'd be right. But as far as...
That's exactly what we did to Almari.
Well, but there are many instances in the case of Padilla, the fact that he was in the military justice system, or military system, did not prevent him from getting fulsome judicial review in 2 district courts and 1 court of appeals. I mean, as a general proposition, there's nothing wrong with government treating, let's say, unless you can demonstrate some incredible bad faith, there's nothing wrong with government treating somebody for a long time as an enemy combatant, provided the facts support it, transferring this person to the criminal justice system, trying that person, failing to carry the day, and then transferring the person back to military
But
justice.
I mean, David, you just said something that I think is critical, which is provided the facts support it, right? So suppose a case where you have someone who is not an enemy combatant, presumably, and whom you and I could agree is not an enemy combatant. Presumably, the government could litigate that habeas petition all the way up to the cert stage in the Supreme Court, and then at the last second say, oh, okay, we agree he's not an enemy combatant. We're going to try him in a civilian court. Now, one time that might be fine, right? 2 times that might be fine. But at some point, I think a district judge is going to say, you know, wait a second, this is abusive.
That's fair, but that's not. It's a fairly narrow situation. There are lots and lots of other instances where such transfers would not play that role. But anyway.
I mean, I think that's right. But I think the timing, I mean, to whatever extent it is an anomalous situation, it is an accurate description of the timing, if not the motives, in both Almari and Padilla.
Questions? Right?
Mr. Ringwell, I was wondering if you could amplify your comments.
Just wait for the microphone.